Morning's docket. That is case number 112037 in the matter of Eric Michael Gamble.
May it please the court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, may I reserve 2 minutes, please, for rebuttal?
Did you say 2 minutes?
2 minutes, please.
Yes, that's granted.
Thank you. Justices, counsel, this original action is before the court after a hearing panel considered evidence on May 13th of 2014 and concluded that the facts clearly and convincingly demonstrated that the respondent's conduct violated KRPC 8.4D, conduct prejudicial to the administration of justice, and 8.4G, conduct that adversely reflected on the respondent's fitness to practice law. No exceptions have been taken to the report. The panel recommended a 60-day suspension. The facts of this matter called for the panel and now call for the court to assess the line between advocacy and intimidation. While the rules contemplate zealous advocacy, they demand that we as professionals respect the rights of third parties, whether that be an adverse party, whether it be a third person in the judicial system, the court, or other professionals. For the third time since the respondent's admission in 2003, the respondent's been involved in answering a disciplinary complaint that alleged conduct demonstrating an absence of an appreciation for these boundaries. The formal complaint alleged that the respondent had violated several rules of professional conduct when he contacted via Facebook the biological mother, a non-client, urging her to revoke her consent that she had granted 9 months before to the adoption of her infant child. Just 2 days before sending the message, which had attached to it a revocation of consent to adopt, this mother had been deposed by the respondent. And in her deposition, she described the circumstances surrounding the birth of the child, as well as her considered decision with her family to consent to that adoption. She indicated in her deposition that the proceeding was emotionally exhausting and that she was not prepared to be a mother. 2 days later, via Facebook, the respondent sent her an emotionally charged message suggesting that she still had time to make things right. The panel concluded that the email message contained false information of fact and an inaccurate statement of the law, and that was an effort by the respondent to manipulate, they used the word manipulate, the young mother. In its report, the panel characterized the communication as bullying. Further in the report, the hearing panel described the email as intended by the respondent to be, well, they referred to the message as emotional blackmail, and that it was designed to embarrass, burden, and create guilt. The panel concluded that the preparation and presentation of the revocation of consent, a document with significant legal consequences, constituted offering legal advice to an unrepresented party without the suggestion that she seek counsel. They concluded that his conduct interfered with justice, a violation of 8.4D. I alleged that it also was a violation of KRPC 4.3. This court, of course, can and may very well assess the facts and reach its own conclusions concerning what violations are established by the facts, but it remains our position that this legal advice rendered to the party who had taken a position that was adverse to his clients was a violation of 4.3, that it went beyond what the comments suggest, in that in dealing with an unrepresented party, the lawyer should limit their comments to a suggestion that they get counsel.
Ms. Baird, I note that he apparently self-reported this to your office on June 28th, 2013, but that there was a hearing the day prior to where this communication was discussed with the court.
There was.
Is there any indication that the court or anyone else was going to refer this as a result of this? I won't label the conduct yet until I hear from him, but based on this conduct?
Not to my office. I'm not aware of that. I don't know whether or not there was some indication to the respondent made by the court that wouldn't be on the record.
And the violation that he characterized it as giving legal advice or something like that.
Yes.
That's how he characterized this correspondence
Yes.
to the victim here.
He characterized it as providing legal advice,
Okay.
that it went beyond what he probably should have offered under the rules. He also suggested that the facts, he may have gotten his facts wrong. He suggested in the email, and the email is in the record, he suggested that the reason that she didn't know about the hearing was because the adoptive parents didn't want her to know about it. In fact, she'd been subpoenaed to the hearing by the adoptive parents' counsel. He also suggested in the email that that there was a good chance she'd be able to keep the child in spite of the Kansas statute that indicates that a revocation of consent freely, and a consent to adopt that's freely and voluntarily offered may very well be very difficult to revoke. And certainly he was aware of no facts, given the fact that he had deposed her just a few days before, of any facts that would have supported a revocation.
There were also some findings by the hearing panel that had to do with his attitude regarding the hearing, and you care to comment on that? There were certain findings that there was some sort of almost a conspiracy against him by your office, and some other kind of minimizing the conduct in this case.
One of the words they used was abysmal, his abysmal attitude with regard to the hearing. They pointed out that the respondent testified at the hearing that he didn't really prepare for it, that he was the only one injured by the disciplinary process. His having to be there really was the only demonstrable injury. And did comment that he felt that he was being singled out, that other lawyers do a lot of other, that don't get sanctioned for things all the time. The respondent's conduct at the hearing, of course, in reading the hearing panel report was troubling. This was, the email message went out in June. The hearing was 11 months later. There was no appreciation for, no real appreciation for the problematic, his conduct, his communication with this young mother. Bullying. It's what the panel concluded, that it was bullying. The respondent testified at the hearing that 40 to 50% of the cases that he handles involve unrepresented persons, not clients. So 40% to 50% of the time, he's dealing with situations where other parties are not represented.
Returning to the rules that the panel concluded were not violated, they determined under 4.1A that there was no evidence that the defendant had acted knowingly, that rather he had made negligent and reckless misstatements.
Right.
Why would you disagree with that?
He testified that his practice had been for almost 10 years, largely involved in domestic cases. He testified that he handled many paternity actions. He was, although he indicated he wasn't aware of the statute, I certainly would suggest that he should have been aware of the statute.
And is that sufficient under our standard for knowing?
Well, I think it's certainly reckless. Whether it established that he knew that he was making statements that were materially false. I can't say that I presented evidence where it established he actually knew that the statements were false.
And then you were talking about 4.3 and the fact that he violated the language in the comment. But as I read the hearing panel report, they felt that they couldn't make that finding or that conclusion of law because that comment language is not incorporated into the black letter of the rule. Are you aware of authority that allows us to go into the comment and to find a violation based on that type of language?
Well, the rules provide that comments are to provide guidance on how we apply the rules. In the scope of our rules of professional conduct, it tells us to look to the comments to determine how we apply the rules to actual situations. And you'll find in the comments many different situations that are demonstrative to lawyers to determine how we apply this. I would suggest that simply concluding that because this line is not in the rule doesn't support a conclusion that there's not a violation. The comments give us guidance. How do we deal with an unrepresented person? The comments provide an indication that 4.3 means that we aren't to offer legal advice to an unrepresented person other than say, go talk to a lawyer.
And then with regard to 4.4a, do you disagree with their conclusion there that there was a valid purpose because of his representation of his client? And
well, I think the controlling word there is no substantial purpose. And should we look into whether it's a legitimate purpose? I think yes. Every time you have a client, no matter, if you can say I did it because I wanted to make a better case for my client, that's a substantial purpose that I don't think gives us license to do whatever we want. He indicated that he was trying. His client wanted to be the father of this child, and that he wanted her to revoke the consent. Because he articulates that my purpose was to advance the interest of my client, is that sufficient? I would suggest no, that we have to look at whether it's a legitimate purpose. Otherwise, saying I'm doing this because my client wanted me to, or I thought it would make a better case, that would be sufficient in any case.
Any more questions? I see no further questions. Thank you, counsel.
Thank you.
I'm sorry, did you have further presentation?
Nothing, no, thank you.
Thank you.
John Ambrosio on behalf of the respondent. The respondent self-reported his conduct, and I can't find anything in the record where he was ordered to do so. He knew what he had done was wrong, was a violation of model rules. He reported himself. Then he represented himself at the panel hearing. And there starts the long slide into the Supreme Court. His conduct that led to his self-report was egregious. There's no doubt about it. And he will admit that today. It was wrong. It was violative of the model rules. Then his anger controlled him at the hearing where he lashed out at Ms. Baird, lashed out at the system, and we all know that that's wrong. He came in to see me, and I suggested, and it's kind of interesting when I suggest anger management for people, or when I suggest that they need therapy, but I said you need to learn that anger is okay. It's how you use anger that's not okay. He took up the cudgel, went to therapy, and is working on his anger management and on those issues as we speak, and has been working it on a weekly basis. I don't know what happened at the hearing that made him so angry. I don't know why he would lash out. Because that's the worst thing you can do in a panel hearing. When you're there, the best thing in a panel hearing is to be on bended knee and to be apologetic. Because if you make a mistake, if you violate the rules, our rules say you must fall on your sword. He either didn't know this or his anger controlled him and he was unable to do it. This is a bright, bright young man. This is a man who's a sole proprietor. He practiced by himself. So consequently, he has nobody to bounce things off, which has always been a problem in the practice of law. And it's becoming worse as we speak. He's bright. He works hard. He represents his clients, but he becomes their champion, which always leads to problems. And in this case that's before you, he thought that this young woman should be the mother of the child. She should raise the child. It's not his choice. It's not his decision to make. It was hers. And I trust and I hope that he sees that now. He was misguided. He was overwrought by his own parenting problems he had over the years. He takes care of his child. He raises his child. The child is with him all the time. And he lashed out at what he saw as someone not doing the job, that he thought this young woman should have raised that child, and he lashed out in anger, he lashed out, he was misguided, and then it became even worse once he got to the panel hearing. He's on the road to recovery, he's on the road to changing, he's on the road to understanding. And if you look at paragraph 51, the misconduct in this case occurred just a few months after the respondent was strongly admonished by a previous hearing panel. The respondent's misconduct in all three of the attorney discipline cases is linked by the respondent's overreaching approach and failure to recognize reasonable boundaries. He can't say no. He can't tell the client, this is your case, I can't do that, just like my colleague described. Accordingly, based upon the findings of fact and conclusion of law, the hearing panel recommends the respondent be suspended for a period of 60 days. My client says, I am learning, I'm willing to learn, this has finally been an eye-opener for me, and I want to be publicly censured and give me a chance to practice law. He is working his program, and I know I say that a lot, but his program where he's not as bellicose, he's not as bombastic, where he is working his therapy to use when to focus that anger. And anger in the practice of law can be a terrific tool if you use it correctly. It gets you going, it gets you fighting for your clients, but lashing out at people is not the excuse, and my client knows that now. With your permission, he would like to address you for a few moments.
Has
Certainly, Your Honor.
there been any contact with the recipient of this correspondence and any kind of response by your client? Any kind of begging for forgiveness, anything like that?
To the best of my knowledge, that's no. And my gut feeling is this young woman probably doesn't want to hear from him. But that's my guess, Your Honor. I don't have an answer to your question.
How would you justify the requested discipline, the published censure, in light of the serial nature of the complaints that have been found against him previously and this one? And they seem to have a common thread.
And you're right, they do have a common thread. He's inexperienced. He didn't get it. He didn't have anybody to help him out, hence a public censure as opposed to 60 days or more than that. I'm seeing everybody needs to be hit in the head occasionally, and a public censure will hit him in the head. The panel decision probably didn't make a dent. And Your Honor, I don't know why. It would scare me to death to be involved in a panel hearing where I was in the dock. It apparently did not have any impact on him either time. Now, being up here in this room before you, or being scared to be here when he first came in to be back in June, it has had an effect. Hence, I'm hoping that you'll give him a shot and a chance.
Did he receive the final hearing report on the prior case?
He had.
And that paragraph 65 says, if the respondent engages in future misconduct, the hearing panel would suggest to any future hearing panels that the respondent's chances have been used up.
I agree. I hear that.
And that wasn't sufficient for an intelligent young man to understand what is expected?
Apparently not, Your Honor.
Okay.
Apparently not.
Okay.
But he gets it now. He absolutely gets it now. With your permission, he would like to address you.
Please, the court. I understand. I'd like to apologize first to Ms. Baird for my comments at the hearing. They were out of control, and they were done with anger that I have, anger that I've been dealing with for a long time, and I've never gotten help for it. When my lawyer advised me to do it, I took the opportunity to do it right away, and I've been meeting with my therapist on a weekly basis. She had a baby last month, but I've been meeting with her consistently since then to work on these things. My actions to the witness, the person who was damaged or aggrieved in this case, were once again out of control. I go over the line sometimes in my practice when it comes to my advocacy and zealousness, and it gets me in trouble. It started off here in Topeka in my practice, working for Legal Aid in 2003, and very zealous advocate at that point. The first panel, the first hearing or complaint that I had was back then, around that time. And it was because I contacted someone's client at the time, trying to be doing too much, going across the line, violating ethics rules. I accepted that diversion, successfully completed it. The second time, the complaint arose out of a domestic, with my own personal domestic issues, and my actions again, crossing the line when it comes to advocacy, and a lot of my actions that get me in trouble are related to some anger and emotional issues that I'm working on. And in this case, it reared its ugly head in a big way. My comments at the panel to Ms. Baird and to the committee did not accept responsibility, and I'm here to accept responsibility today. I didn't have a lawyer. I should have had a lawyer from the beginning. And now, I mean, when I look back on all of this, and I am making changes in my life. I'm making changes in my practice. I'm very reluctant to even speak with anybody who's underrepresented. My communications now are in writing with everyone as far as telling them to get a lawyer. Excuse me. I apologize. I apologize to the court and to the public. Lawyers should not do what I did, and I'm accountable to that, and I am prepared to accept whatever discipline this honorable court has to offer me.
Counsel, I have a question. The panel found that you self-reported your conduct in a letter that you sent to the disciplinary administrator.
Yes, sir.
And my question is, was there something that made a light bulb go off in your mind and you said, oh, what I did on this occasion perhaps was not the best thing I should have done? Or help me understand, was there an event or just a realization, or someone told you you should not have done this? How did that come about?
The court, the judge, at that hearing, the other attorney referenced it in court. He raised the issue in court. And after hearing that, and after we had that hearing, the light came on. I was like, yeah, that was wrong. What I did was contact a witness whose interests may be adverse to my clients. And I realized it. Right? In the moment, I didn't realize it. And actually, it's in the record. The court never told me to report. The court, and Ms. Baird actually subpoenaed, or she has the transcript. The transcript was ordered of that hearing when this issue was first raised in court. And the court never requested or instructed. I realized it after the hearing. Because it's serious.
And your letter itself says, I wish to self-report a likely violation.
Yes.
Those are your words. And so my question is, if you have self-reported a likely violation and you're in a hearing to see whether it indeed was likely or actually was a violation, I'm having trouble understanding why you lost self-control in that hearing.
I didn't have an attorney, and I let my anger get the best of me. I mean, I felt attacked. You know, I felt attacked by Miss Baird, and that's not how you handle a situation like that.
What happens, Your Honor, I think, I may get in an argument with the justice, and then it's over for me. I may get in an argument with a lawyer, then it's over. He needs to work on that. He needs to stop taking it so personally. Because if those of us who've been in the practice of law, we get in an argument and we worry about it or argue about it or think about it or let it eat at us for the next even hour or so, it ruins your life. He's working on that. He's got to let it go, and he can't. Ms. Baird's doing her job, period. He may not like it. He may not like that he's the focal, and I think he's working on that part of it now. I think that answers your question. I don't know if that helps.
Well, even though he says, I'm self-reporting, I'm sending this information in, and a hearing notice arrives and it goes to the hearing, and then he loses self-control.
And I have no answer for that. I really don't. I hear that.
All right.
And that's what he's working on.
Mr. Ambrosia, I'm feeling like I'm in a corner that I don't want to be in.
Okay.
And I want you to help me out of it. I don't like either option as I'm sitting up here because I don't think it's getting at the problem. I mean, you're telling me he's in therapy, he's going to continue in therapy. Okay, I'm fine with that. I want him to do that. But this isn't so serious that we're talking about how you re-enter into the profession completely, but we sort of have that. I mean, we've got an element in here, and I'm trying to figure out whether, with your experience, you think there's a way to structure something that would include some probationary terms that would require not so much supervision of the practice as much as of the respondent to continue therapy and have someone checking up on making sure that therapy is done. I mean, I'm having trouble with our responsibility to protect the profession and the republic and the public. I'm less concerned about these 3 violations and how we address them, whether public censure or 60 days is enough. I mean, I don't like 60 days and then nothing after that. I don't like public censure and nothing after that.
And I struggle with the same thing you struggle in all of these cases. And I wouldn't have had an answer except I remember the Ponte Flores case where he was having trouble with his child support, where I represented him. And you gave The court put him on probation and said, if you make a mistake during the next 5 years, you're going to be back before the court and we're going to take your license. And I believe that was the case. I only know that not because I read the law, but because that was my case. And I'm wondering if you can, as the court, can simply say, just what you said, the majority of the court doesn't agree with either one of these, but if he continues, we'll put him on probation, bench probation, and we want him to check in with the disciplinary administrator's office on a monthly basis, every 2 months. You can do anything you want, and he would comport himself accordingly, like he did in the Flores case. And if he makes a mistake again, drag him back here. The problem I have is the same problem you have. We don't have enough layers of discipline, and we don't have enough reporting ways to check up on people once they come through the court. And I agree, and that's the only way I can think you do it. And I hope I took you out of your corner on that.
Let me, maybe, we're talking about how this is somehow just barely crossing the line or crossing the line. This is so far beyond the pale. I mean, you read this correspondence, it's a man that is mean, is angry, and has no control, and will go to any bounds to, I don't know how to characterize it. They said emotional blackmail. Well, it's beyond that. It's just, and that's my issue here, is how do we protect the public based upon your client just, I don't even think appreciates to this day how we characterize this kind of conduct.
I hear what you're saying, and I hear what Justice Biles is saying, and he's appreciating it, he's working through it. The conduct, I overuse the word egregious. I agree with you.
I mean, and again, this is the third time within about a year period this is going on, and there's some indication that, I understand the steps you're taking are admirable, but there's just an appreciation. I don't think there's an understanding or comprehension of this particular kind of conduct after he's been warned 2 or 3 times.
You're talking about the anger, the lashing out.
I'm just talking about the whole nature of this correspondence is outrageous, just outrageous.
I would agree with you, Your Honor. It is very outrageous. Should have never wrote it. Should have never said it. Should have never even. I'm sorry, and I'm working on it. I am working on it. I promise you that, and I'm going to continue, whatever the sanction might be. I'm going to continue it.
Do you have a filter associate? I mean, I know you practice by yourself, right?
No, I'm the only one in my office, my building. We office shared for about 3 years, but no one's been in my office for 2, and even then, everyone's coming and going. I don't have a supervisor.
It's kind of the proverbial writing the letter and then not mailing it. I mean, it seems like you react to your anger very quickly, and
Yes, I do. It affects me not only in my professional life, but it affects me in my personal life, my daughter. There's some things that the therapists have pointed out, and I'm learning to deal with it in better, more appropriate ways. But I am receiving help, and I do realize the severity of what I did.
Do you have any further questions of either counsel? Any further presentation? All right, thank you both.
Thank you.
You reserve 2 minutes for rebuttal.
If I may point out a few things, this email was not, there's no evidence that it was written in an emotional outburst. This wasn't a face-to-face conversation where he could not control comments. This is a calculated email. It's lengthy, it's thought out, and this is sent after he drafted a pleading for this person to sign. I would suggest that this conduct, his calculated decision to draft a pleading, which is absolutely contrary to what this witness had told him 2 days before what she wanted to do, and then formulating this, I don't think we can just brush it away as an angry outburst. I did request at the panel hearing that they consider a suspension and a 219 hearing, and I told the panel, I'm not sure what needs to be required at a 219 hearing because I'm not sure what's causing the respondent to engage in this repeated conduct. I don't know the answer to that. This never should have happened. The pleading never should have been drafted. The email never should have been sent.
Remind me again where you are on discipline.
I'm requesting that the court consider a definite suspension of 6 months with the 219 hearing and allow this respondent to continue as he's testified or as he's provided to the court therapy. That is I think it's a positive development that he's maybe exploring why some of this conduct may have occurred. I'm certainly not convinced that we're at a point where he can continue practicing right now without demonstrating to 3 peers that he has addressed the conduct that the panel concluded adversely reflected on his fitness to practice law. If this is related to an anger issue or some other issue, we have an opportunity to find that out and to make sure that he is addressing the issue in a way that will protect other persons from this type of conduct. This is particularly egregious email. It's an adoption situation. It created, excuse me.
You go ahead. Finish your thought.
Permanency is fundamental. A seek of permanency in an adoption. To interject this email into this situation created significant injury to the mother, to the adopted parents, and to the infant. He's offering legal advice to a party who's taken an adverse position to his client. And whether it be reckless, knowingly providing false statements. You were going to ask a question.
I was. If you could do the math for me based on your experience, if we went with a 6-month suspension and a 219 hearing, realistically, when would he expect to be reinstated in the practice of law?
Well, if the petition were filed for reinstatement immediately after the 6 months, if ordered by the court, then depending upon what was provided, if a reinstatement application comes in with documents demonstrating reports, demonstrating here's the records relating to my continued treatment, here's my plan as I continue into practice, here's what I'm going to do to keep this from moving forward. If the effort is done and presented with a reinstatement, then I would hope that a panel could be impaneled and consider the testimony within 3 months, but I don't. So 9 months.
9 months would be,
and that's speculation. Excuse me.
9 months would be the minimum, you believe, from the time of his suspension until he got his license unsuspended?
That's a best estimate. I haven't been involved in a reinstatement hearing that would allow me, from my own personal experience, at least in terms of one of the cases that I handled, then applying for reinstatement.
All right, and my follow-up question is, do you have an opinion on the impact on an attorney's sole practice of a 9-month loss of practice of law?
Significant. It has to be significant. It would also depend on whether or not there's a license in another state and whether or not there's a period of time where actually you can practice on one side and not another. That may impact a solo practitioner. But clearly it would have a significant impact, which is, I suspect, why perhaps the hearing panel a year ago said, let's admonish. Even though this conduct warrants suspension, let's admonish and hope that gets the point across so that we don't have to go there. And that in the event he finds himself back in the system, there's a very real possibility that this will happen.
All right, thank you. Any further questions? Thank you all for your arguments this morning. Clerk will take this matter under advisement.